Hello friends, I am Gurpreet Singh Power Advocate. Today I am going to discuss a very important topic of Limitation Act with all of you. As we know that there is section 3 of the Limitation Act which mentions that any suit filed or application filed or appeal filed after the expiry of the prescribed period of limitation that will be dismissed as time barred by the courts. But there are certain exceptions under the Act from section 4 to 24 of the Limitation Act which lays down that there is certain period which should be counted and which should be excluded from computing the period of limitation. So there is section 18 of the Limitation Act which lays down that in case there is any liability or right arising in favor of one person and against the other person, and there is a period of limitation for filing any suit or making any application regarding that right to property or any other right by any other person, then in that case that suit, that application must be filed within the period of the limitation, and if before the expiry of the period of that limitation acknowledgement is made in writing and signed by the person concerned, then fresh period of limitation will commence from the date when the acknowledgement is signed. For example, A wants to recover rupees 1 lakh from Mr. B, and let's suppose period of limitation was to expire on 31st December 2021, and on 30th December 2021 B makes a written acknowledgement signed by him that he will pay the money of A. So this acknowledgement will extend the period of limitation and it will provide a fresh period of limitation to Mr. A. Now, where the period of limitation is mentioned for such type of relief, it is mentioned in Article 19 of the Indian Limitation Act, which provides 3 years of the period of limitation. Now, our topic is going to become very interesting because there is a latest landmark judgment by Honorable Supreme Court of India in 2025. The title of the judgment is Messrs. Aaron and Associates versus Sanmar Engineering Services 2025 Supreme Court. Honorable Supreme Court has laid down a very important point in this judgment. It has held that no doubt when the acknowledgement is in writing and signed by the parties made before the expiry of the period of limitation, definitely it is going to provide the fresh period of limitation for recovery of the debt or for any property or any other right. But where the acknowledgement is admitting the part liability, then the plaintiff is not going to get the full benefit or benefit of a full liability. So, example, where plaintiff wants to recover rupees 1 lakh from the defendant and he sends the legal notice to the defendant that I want to recover rupees 1 lakh from you, and the defendant admits only 10,000 rupees. Now the period of limitation will be extended if this acknowledgement was made prior to the expiration of the period of original limitation. But now in fresh period of limitation only 10,000 can be recovered by Mr. A, by plaintiff from the defendant. He cannot recover the amount of rupees 1 lakh. This is very technical law laid down by Honorable Supreme Court, and I hope all my fellow advocates will get benefit out of this case. Thank you.